Okay. Dan May, District Attorney. As you know, we just had a hearing on the Frazee case. We were set today for arraignment. We have postponed arraignment until May 24th at 8:30. We put on the record today, and so did the defense counsel. We're still waiting for some testing to be done of some of the evidence, and we'd like to get more of that testing done before we hold arraignment. Quite frankly, if we'd set a trial date today, it would have probably been around August, and because of where everybody's waiting for testing, it most likely would have postponed that trial date to another date. So all the parties, the judge, the attorneys are trying to set a realistic date. In our jurisdiction, by the way, almost every homicide case takes about a year or so to get to trial. So it's something that we kind of know in the course of testing getting done, witnesses being prepared, people getting prepared on their cases. Most cases take about a year before we get to trial. As you know, in this case, the arrest was made back in December, so that gives you kind of a time frame that we're on. So that was primarily what happened today, is postponing arraignment, which is arraignment, by the way, is when the defendant pleads guilty, not guilty by reason of insanity. So that's the date that he does that. That starts to trigger future dates because you have to set trial within 6 months of an arraignment. So that's what happened today.
Can you elaborate a little bit? What kind of testing?
I think we've put on the record before that we have some potential destructive testing of some of the physical evidence. So that's something that the parties are working out on how to do that. When I say that, some tests you can do where under Colorado law, if we can do a test and get a result and still have some of the evidence for the defense to do a separate test, then we just do that. There are some items that may be so small or a particular type test that you can only do it one time and the defense doesn't have an opportunity to do a second test. And so then the parties try to work out how they will do that so that both parties can observe the testing and see how it's being done, because it can only be done once. And so we put on the record before that the parties are working out those procedures on certain items on that destructive testing. Otherwise, it's just kind of routine testing.
So in other words, some of that evidence hasn't even been tested yet.
Correct. Some evidence has been tested, and you've heard about that at the preliminary hearing of what evidence has been tested in the past. Other items, counsel on both sides maybe look at the case and decide they need other things tested that they feel would be important for the jury to know one way or the other. And so both sides kind of work independently of each other of how they view the case and what things they want to have tested and what they think may be important going down the line. The landfill questions, the chief isn't here today, but that really should be, that's something you want to ask the chief of police on that, where they stand on the landfill. That's part of the investigation, and so that's more in his realm. That's the appropriate person to talk to and what the status is on that.
What about the social service issue?
I'll ask Beth Reed to step forward and to answer that question.
So you may recall that at the preliminary hearing there was discussion of records and the lack of DHS reports regarding possible abuse by Kaylee Barrett. And it was testified at the preliminary hearing that there were no reports prior to Mr. Frazee's arrest regarding these records. The records that we're speaking of today are simply standard records that are generated by the Department of Human Services after an arrest is made and when there's a child protective issue that's pending.
So these are things that happen post-arrest?
They are post-arrest records.
Thank you.
Dan, can you talk about the tiny evidence that you're still testing? Is that blood? Can you be a little more specific?
Did we put on the record last time what it was? It hasn't been put on the record what the item is, so I can't comment on what the item is. Generally, in any case, you can look at fingerprinting, DNA. You can test for blood. There's a lot of forensic testing that can be done. I don't think we've put on the record yet what this particular item is, so I'm not at liberty to be able to say that yet.
You've done a lot of this sort of work, Dan, and you've had some time to think about this case. Where are you on whether or not this is a death penalty case?
Again, under Colorado law, death penalty decisions aren't made until after arraignment. By law in Colorado, Once the defendant enters a not guilty plea, we have then 9 weeks to decide whether this is a death penalty case or not. So we have not arrived at the arraignment yet, so it's a decision that we haven't arrived at yet.
But you can't give us a sense of where your thinking is?
No, I very much follow the laws of the state of Colorado when it comes to that particular issue. It's obviously a huge decision for any DA's office, and it's meeting with the victim's family, talking with the defense, and things like that. But again, under Colorado law, those decisions aren't made by law until after arraignment.
Can you tell us where the evidence is specifically coming from, whether that be her apartment or one of the Frazee properties?
Certainly, we put in the preliminary hearing where a lot of evidence was collected, but I can't comment on the particular items that are being tested now where they came from because we haven't put that on the record.
It's a long way off, but do you anticipate the defense asking for a change of venue, just considering how small the population of this county is, and the fact that everybody seems to know everybody?
That's a question you might want to ask the defense, whether they want to do a change of venue. I don't believe by law in Colorado the prosecutor can ask for a change of venue. I think that's strictly a defense question, but that's something you'd have to ask the defense attorney if they're concerned about the venue.
How would you react?
Again, I don't try these things in the press. We try these things in the courtroom. If they file a motion, then you'll see our response to that. It is something that is required, I believe, to be in writing. Under the statute, it usually requires affidavits or some evidence of it, but if they file something, then you'll see us respond.
Has there been any inkling, any discussion, any reaching out by the defense team that Patrick Frazee is interested in cutting a plea deal with you?
Again, that's something I can't comment on at all. My ethics codes are very clear that we can't comment on that particular question at all. Okay. Thank you very much. Anything else?